Hey everyone, welcome back to another weekly breakdown. Whether you're a real estate student, an investor, or just someone who geeks out on real estate, this week's topics are a few that can make or break a deal. Today I'll be discussing easements, and I'll also touch briefly on air and subsurface rights. So an easement is a non-possessory right to use another person's land. It does not give ownership, just usage rights, but there are many types of easements to consider. Some of the most common are an easement appurtenant. An easement appurtenant is an easement tied to two adjoining parcels of land. So one is the dominant parcel and one is the servient. The dominant is the one who receives the benefits. The servient property is the one who is actually burdened by the easement. Another example of this would be a landlocked property, where the only way to access the home is through a driveway easement across a neighbor's property. So you can see here in the example, the property in the rear is completely blocked off from a public road, but they do have an easement through the property in front that is touching the public road. They have an easement through that property back to theirs. Another one is the easement in gross. Now, this is an easement that benefits an individual or an entity, not necessarily a property. So an example of this would be like a utility company having rights to run power lines across a private yard, or maybe just an easement where they can access those power lines and perform maintenance. The next one I'll talk about is a prescriptive easement. So this is an easement created through continuous, open, and hostile use over time. So an example of this would be if a neighbor uses a shortcut across your property for say 15 years or so without your permission. By doing this, they may be able to legally secure that access and continue to use it, whether the property owner likes it or not. Now, the number of years is set by the state. For instance, here in Florida, it's about 7 years. But some states like California only require 5 years, and then there's states like New Jersey that will require 30 years. But some states also include some caveats, so make sure you pay attention to what state you're dealing with. They may require more than just usage. There may be a requirement of tax payments, or they have to make some type of improvements to the land. Another one is an express easement. This is an easement written into a deed or contract between two parties. So let's say a developer sells a lot that clearly states that there's a shared driveway and there's some shared driveway rights, and those are recorded in the deed. Another one is an implied easement. This is not written, but it's assumed based on long-standing use or necessity. An example would be you sell off a portion of land that includes the only access to a community lake. The courts may imply an easement even if it wasn't written down. There's also an easement of necessity. This is a special type of implied easement created when a parcel is completely landlocked and needs access to a public road. Remember that first example that we gave? This would be one where it was granted by necessity. The necessity must be strict and not just inconvenient. If there's another way to access the road, that lot can make arrangements, and they'll need to do so. Another common one is a negative easement. So this prevents a landowner from doing something on their land. This would be like maybe conservation, or maybe something you can't build, or you would block a neighbor's solar panel. So as you can see, easements can be helpful when you need access, could be dangerous when you don't know they're there, and they can be valuable if you control one that others need, or they can devalue a property if it puts limits on the property. So before buying, selling, building, or investing, always pull the title report. Get a current survey and ask about historic usage. So after all that, you may be asking yourself, well, how can an easement be removed? Fortunately or unfortunately, depending on what side you're on, easements are often permanent, but they can be terminated under specific conditions. One of those ways is a release. The dominant estate, the benefiting party, can just voluntarily give up the easement in writing. Just remember, it must be recorded with the county to be official. Another one is a merger. If the same person comes to own both the dominant and the servient estates, the easement can merge together and the easement disappears. Another one can be abandonment. If the easement isn't used for a long period and the actions of the easement holder suggest they don't intend to use it again, then it can just be considered abandoned. Now, it's important, non-use isn't enough. Intent to abandon must also be proven. There's expiration. Some easements are created for a fixed time period or specific purpose, and they will expire when the time or purpose ends. This could be like a temporary easement granted for construction. That would be a good example. Then there could also be where the two parties just agree. They just agree to terminate the easement. Like the release, this must be in writing and recorded. Another one, if it was an easement out of necessity, and then the necessity ends, so does the easement. If a new road is built and that landlocked parcel that we discussed earlier is no longer landlocked, something like that. Finally, there's court action. A judge may terminate an easement in a dispute, especially if it's been misused or if laws have changed. Now, since I'm talking about easements, I thought I would go ahead and throw in air rights and subsurface rights. So you technically own the air above your property, but not infinitely. The FAA regulates navigable airspace, so they kind of have an easement to your airspace, so to speak. Obviously, you can expand and build up on your property, but the air parcel above your building can be sold or leased. So sometimes telecom companies will want rooftop access to a skyscraper so they can add towers or signals. In New York City, there's a famous case where the developers of the MetLife building bought air rights from the Grand Central Terminal to build vertically without having to demolish the historic structure. Naturally, this also means you have subsurface rights, which can be important since they may involve oil, gas, minerals, or even groundwater. Now, this is not common here in Florida, but I once read about a property in Texas where the surface rights were owned by a local family, but the mineral rights had been sold off decades ago to an energy company. When an investor tried to build residential homes on the property, guess what? The oil company showed up with their drilling rights and destroyed the developer's plans. But it was all completely legal, and I guess somewhat common in energy-rich states like Texas. So obviously this is something the developer should have discovered and addressed during his due diligence period, but that is sometimes difficult. And I'll give you an example why. So let's go back to easements. There was a case here in Florida where the city built a huge water pipeline that was not recorded correctly. And over the next 100 years, hundreds of homes were bought, sold, and built over that easement. Now here's an example of one of those properties where the water main that runs underneath that property supplies water to over 300,000 residents. And it's located under their pool. It's located under their lanai, under their home. Not only could this require the demolishing of the home if repairs were needed, but if that pipe ever ruptured, the power and pressure would cause catastrophic damage. This once nearly $1 million home is now worth only salvage value. So why is all this important? Because you have to understand that these issues exist and that taking the proper steps to find and understand them can enhance value or create costly value and legal nightmares. The title company and surveyors play a huge role in this, but it's important for everyone involved to be vigilant and look for warning signs that issues could be present. So now that we're all going to stay up all night and wonder who's crossing over our land or what pipes are buried under our yard that we don't know about, it's time for me to go. I hope to see you guys next week. And until then, keep learning, investing, and do not hesitate to reach out. If I can help in any way, I'd love to. See you next time.